and I will begin with an opening statement, turn to the ranking member, Senator Cruz. Thank you for being here. And then if any of my colleagues have statements, we will hear from them. Congress enacted the Voting Rights Act, as you all know, to confront one of the country's most enduring and deepest faults, the continued denial of equal participation and representation to citizens on account of their race. A century after the Civil War ended, our nation still failed to eradicate the blight of racial discrimination in voting, and the promise of political equality remained unfulfilled for Black citizens. In accomplishing what the ratification of the 14th and 15th Amendments had failed to do, the Voting Rights Act became, in the words of President Lyndon Johnson, quote, one of the most monumental laws in the entire history of American freedom, end quote. Congress reevaluated the continuing necessity of the Voting Rights Act 5 times between 1970 and 2006. Each time it authorized the act with overwhelming bipartisan support. Congress didn't take this task lightly. Each authorization was accompanied by countless hearings, voluminous fact-finding, and it consistently led to the conclusion that the Voting Rights Act played and continues to play a continuing, indispensable role in securing the Constitution's promises. Because of the Voting Rights Act, the Department of Justice and ordinary voters were able to use the pre-clearance process to halt the implementation of well over 1,000 discriminatory election rules proposed by state and local officials before those rules went into effect and had a repressive impact. But in recent years, the Supreme Court has all but disregarded Congress's judgment about the continued need for the Voting Rights Act and has begun undermining the core protections, including pre-clearance. Most importantly, for the purposes of today's hearing, in 2013, in Shelby County versus Holder, the court rendered a 5-4 intensely partisan decision that overruled Congress's judgment. Although the court ostensibly left pre-clearance intact, it invalidated the formula that determined which jurisdictions were subject to pre-clearance, and it thereby rendered the law essentially dead letter. This year alone, we've experienced the most destructive legislative session for voting rights in generations, with states and localities enacting a torrent of new voting restrictions. Between January 1st and July 14th of this year, more than 400 bills that included provisions that restrict voting access have been introduced in 49 states. During that time, 18 states successfully enacted 30 laws that made it harder for people to vote. These laws make mail voting and early voting more difficult. They manipulate the boundaries of districts to reduce minority representation. They've led to a purge already of up to 3.1 million voters from the rolls in areas that were once covered by the Voting Rights Act pre-clearance requirement. Through decades of experience, Congress has learned that much of the success of the Voting Rights Act came from its capacity to meet ever new forms of discrimination. Justice Ginsburg, in her very powerful dissent in Shelby County, pointed to the vile infection of racial discrimination in voting and said it, quote, resembled battling the Hydra. Whenever one form of voting discrimination was identified and prohibited, others sprang up in its place, end of quote. Today's reinvigorated efforts to deprive members of minority groups from equal access to the ballot box through more subtle second-generation barriers proves that a new pre-clearance regime is needed now more than ever, and that's why we are here today. Our response to the Supreme Court's decision in Shelby is the John Lewis Voting Rights Advancement Act, passed by the House this year and introduced in the Senate last Congress. It includes new formulas to revive preclearance and protect the right to vote. We're here today to focus on one of those best known practices, or practice-based coverage formula, which specifies types of restrictive practices that we've seen again and again and again, repeated, known practices. They impose discriminatory effects, and our goal is to prevent those discriminatory effects in areas of increasing diversity before they can do damage. The new practice-based preclearance regime responds directly to the Supreme Court's concerns with the prior preclearance formula, and it will allow the Voting Rights Act to keep pace with present conditions and America's rapidly changing demographics. It is narrowly tailored and targeted, let me repeat, narrowly tailored and targeted to those known practices that have been repeatedly used to suppress the vote based on discrimination. Protecting that right to vote, the equal opportunity to participate in the political process, is not a matter of partisanship, but of fulfilling the founding ideals of our nation. Nothing is more fundamental, nothing, than the right to vote, and we must protect it from the torrent of restrictions that threaten it. Thank you all, and I now turn to the ranking member.